So it's another day, yeah, another day to bring you premium legal tips. Like we have always promised that this is a platform where you get premium legal tips to help you make informed decisions, help you live informed life and discover the very best version of yourself. So we have been considering the provisions of the Nigerian Data Protection Act of 2023. The things that I bring to you are not fabricated. I bring the law to you unadulterated. I bring the law to your doorstep. This is evidence of careful study to bring the law to you because we believe that the proper information will help you make informed decisions. So the essence of this is to help create awareness of the laws that are in operation in our system, to know when somebody owes you a certain duty or obligation and whether the person actually is performing or has performed it and what rights you have under the law. So whether as a lawyer or an individual who just wants legal insights into Nigerian legal system, we've got you covered. So today, let us consider the principles that govern data processing in Nigeria. We'll be considering number one, the principle that says that the process of collecting an individual's personal data must be fair, must be lawful and transparent. There should not be any shady deals, must be transparent. It should not be unlawful. There should not be any form of illegality found in the process of collecting personal information. Okay. Then number two principle is that the purpose for which you are actually collecting the personal data must be explicit. So after you have given the purpose for collecting that information, you will not go ahead to use that same information for any other purpose that is incompatible with the initial purpose that you have stated right from the very beginning. Okay, so the third principle is that you should not retain that personal information longer than is necessary, knowing fully well that there is the duty of confidentiality and the duty of integrity. So when you hold on to that information for too long, will you still be able to guarantee confidentiality and integrity as to the privacy of the data subject? But where you have already stated the purpose explicitly, but now you want to do a further processing on that information, does the law allow it? The answer is yes. The law allows it. You have stated the purpose from the beginning, but now you want to act more on that information. The law allows it, but you must consider the following. One is whether there exists any relationship between the original purpose and the further processing that you want to do. So you must also look at the consequence it will have on the data subject. Will the data subject be placed to under higher risk? Will the data subject be exposed to more risk? So these are questions that you must also ask yourself. The consequence on the data subject. You also look at the safeguard that you have put in place. Maybe in the initial purpose, you have actually put some safeguard to ensure privacy and protection of the data subject's interest. But now you ask yourself, does the safeguard also cover the process, the further processing that you want to do? So these are questions that you must ask and answer yourself in order to act more on the data that you have collected from the beginning. But you must also know that as we are talking about incompatibility of purpose, or where that further processing is for public interest, for archiving, for the purpose of history, you cannot qualify that as incompatible with the initial purpose. I hope you have learned something. This is just one of those days where I've brought you premium legal tips. Yours is to digest it, so you can make informed decision, live informed life, and discover the very best version of yourself. We'll see you again.